A federal judge just issued a ruling that fundamentally eliminated Trump's ability to shift between conflicting defense strategies. During a critical pretrial hearing on January 31st, Judge Aileen Cannon in the classified documents case delivered a 62-page order that legal experts say represents the single most consequential procedural decision in any Trump prosecution. And this isn't some technical ruling about discovery deadlines or witness lists. This is a binding judicial determination that forces Trump's legal team to commit to a single coherent defense theory and eliminates their ability to pursue contradictory arguments simultaneously across different proceedings. When a federal judge issues an order requiring a defendant to choose between claiming documents were automatically declassified or arguing he had authority to retain them personally, you know the strategic landscape has fundamentally shifted. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this extraordinary judicial intervention? According to court transcripts reviewed by CNN and The Washington Post, Trump's attorneys spent over 6 months pursuing fundamentally incompatible defense theories in different forums. In criminal proceedings before Judge Cannon, they argued Trump had declassified all materials through a standing mental telepathy order. Simultaneously, in civil litigation before Judge Beryl Howell in Washington, they claimed executive privilege protected the same documents because they remained classified. Meanwhile, in appeals to the 11th Circuit, they asserted Trump had personal authority under the Presidential Records Act to retain any materials regardless of classification status. This wasn't strategic flexibility or exploring alternative legal theories. This was attempting to weaponize contradictory positions to create confusion and delay across multiple proceedings. And believe me, when a judge issues an order forcing a defendant to reconcile irreconcilable arguments, you know something fundamental has just collapsed. Here's the full picture of what's been unfolding. Tensions between Trump's shifting legal positions and judicial tolerance for inconsistency have been building since August 2023, fueled by contradictory filings, incompatible discovery responses, and what prosecutors described as a deliberate strategy to prevent any court from ruling definitively on the document's status. But everything reached a breaking point on January 29th, when Judge Cannon convened what she termed a clarification conference after prosecutors filed a 38-page motion titled Defendants' Irreconcilable Positions Across Multiple Proceedings. The motion, filed under seal but partially quoted in subsequent orders, documented every instance where Trump's team had argued contradictory positions depending on which court they were addressing. The motion cited specific examples that legal scholars say demonstrate the impossibility of all positions being simultaneously true. In the criminal case, Trump's attorneys filed declarations stating that the former president had issued a blanket declassification order in January 2021 covering all documents in his possession, rendering prosecution impossible because no classified materials were knowingly retained. In civil proceedings involving National Archives access, the same attorneys argued executive privilege protected the documents specifically because they remained classified and implicated presidential communications. In appeals challenging the FBI search warrant, the legal team claimed the Presidential Records Act gave Trump personal ownership of all materials regardless of classification, making the search unlawful regardless of whether documents were classified or declassified. Prosecutors argued these positions cannot coexist because they depend on mutually exclusive factual premises. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Cannon read the prosecution's motion cataloging these contradictions, she recognized immediately that allowing a defendant to maintain fundamentally incompatible positions across different proceedings threatened the integrity of the entire judicial process. And let's be honest for a moment. Orders forcing defendants to choose between alternative theories are relatively rare in federal practice. They don't happen over minor inconsistencies or evolving legal arguments. They happen when a judge determines that a party is deliberately maintaining contradictory positions to gain strategic advantage by preventing any court from issuing a definitive ruling. Here's what multiple sources familiar with the January 29th conference say happened. The proceedings began at 2 p.m. in a secure courtroom at the Fort Pierce Federal Courthouse. Present were lead prosecutor Jack Smith, Trump attorneys Todd Blanche and Christopher Kesey, and representatives from the Department of Justice's National Security Division. Judge Cannon opened by stating that this conference has been convened to address what appears to be a fundamental inconsistency in the defense's positions across multiple legal proceedings involving the same set of documents. She explained that she had reviewed filings from the criminal case, civil litigation in D.C., and appellate briefs to the 11th Circuit. According to the official transcript, she stated, "I find myself unable to reconcile the positions advanced in these different forums, and I am not convinced the inconsistency is inadvertent." The transcript reveals that prosecutor Jack Smith then walked Judge Cannon through a detailed comparison of defense filings using a presentation that displayed contradictory arguments side by side. Sources who attended say the presentation was methodical and devastating, showing exact quotes from different filings that could not logically coexist. When Judge Cannon asked defense attorney Todd Blanche to explain how all positions could be simultaneously valid, the transcript shows a lengthy pause before Blanche responded that each argument was appropriate to the specific legal context in which it was raised. Judge Cannon's response, according to multiple reporters who obtained the transcript, was immediate and sharp. "That is not an answer, Mr. Blanche. Either the documents were declassified, in which case executive privilege cannot attach, or they remained classified, in which case the Presidential Records Act provides no relevant authority. You cannot maintain both positions simultaneously depending on which benefits your client in a particular proceeding." Drop a comment right now if you saw this coming. I read every single one. Now, things get absolutely extraordinary. According to 3 attorneys who were present and spoke to reporters on condition of anonymity, Judge Cannon then did something virtually unprecedented in federal criminal practice. She announced that she would issue an order requiring Trump's legal team to file a single unified statement of their factual and legal position regarding the document's classification status, ownership, and Trump's authority over them. This statement would be binding across all proceedings. Any subsequent filing in any court that contradicted the unified statement would be deemed a violation of the defendant's duty of candor to tribunals. The defense would have 14 days to confer with their client and file the statement. Once filed, they would be locked into that theory for all purposes. The courtroom reaction was immediate. Christopher Kesey, Trump's Florida-based attorney, attempted to argue that requiring such a unified statement violated Trump's rights to pursue alternative defenses and to litigate different legal theories in different contexts. Judge Cannon's response, preserved in the official transcript, has already become required reading in federal criminal procedure courses. She stated, "Mr. Kesey, your client has a right to present a defense. He does not have a right to present 3 mutually exclusive defenses simultaneously in 3 different courts, creating a situation where no court can issue a definitive ruling because the factual premises constantly shift depending on the forum. That is not flexibility. That is manipulation of the judicial process." That's when it became clear this isn't just another procedural ruling or standard case management order. The bombshell moment came when Judge Cannon announced she had already coordinated with Judge Beryl Howell in D.C. and with the 11th Circuit Clerk's Office to ensure the unified statement would be filed simultaneously in all proceedings and would be binding on defense counsel in every forum. Legal experts say this kind of cross-jurisdictional coordination on binding a defendant to a single position is extraordinarily rare and typically reserved for complex civil litigation involving the same parties in multiple courts. Applying it in criminal proceedings represents a fundamental escalation in how courts address defense inconsistency. This isn't the first time courts have forced defendants to reconcile contradictory positions. Think back to the 2006 prosecution of Enron executives Kenneth Lay and Jeffrey Skilling. Defense attorneys attempted to argue in criminal proceedings that the executives had no knowledge of accounting fraud while simultaneously claiming in parallel SEC civil proceedings that they had properly disclosed all material information to auditors. Judge Sim Lake in the Southern District of Texas issued an order requiring the defense to choose which version was true. He ruled that maintaining both positions constituted an abuse of the judicial process. The defense chose to abandon the criminal ignorance theory. Skilling was convicted 2 months later. Then there was the 2015 case of pharmaceutical executive Martin Shkreli, who faced both criminal securities fraud charges and civil enforcement actions. His attorneys argued in criminal court that investors had ultimately profited from his fund management, while in civil proceedings they claimed the investors had been defrauded and deserved compensation. Judge Kyo Matsumoto in the Eastern District of New York issued an order similar to Judge Cannon's, forcing Shkreli's team to reconcile the positions. They chose the criminal defense theory. The civil case was stayed. Shkreli was convicted on multiple counts. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump's own prior experience with this exact problem. During the Trump Organization tax fraud trial in New York in 2022, Trump's attorneys argued in criminal proceedings that executives had acted independently without corporate knowledge or authorization. Simultaneously, in civil fraud litigation brought by the New York Attorney General, they claimed the corporation had properly supervised all executive conduct through robust compliance systems. Judge Juan Merchan forced the defense to choose. They maintained the criminal position that executives acted independently. The civil case proceeded with that factual premise established. The corporation was convicted on all counts. Now, however, the stakes are exponentially higher. This time, the contradictory positions don't involve subsidiary legal theories or evidentiary disputes. They involve the core factual question that determines whether Trump committed crimes at all. If documents were declassified, there is no violation of laws protecting classified information. If they remained classified, the entire declassification defense collapses. Trump's team cannot have it both ways. The pattern is clear. When defendants attempt to game the system by maintaining fundamentally incompatible positions across different proceedings, courts eventually force them to choose, and that choice typically determines the outcome of the case. So what makes Judge Cannon's order so devastating to Trump's defense strategy? According to legal experts who have reviewed the 62-page ruling issued on February 1st, it eliminates every escape route Trump's attorneys had carefully constructed over 18 months of litigation. The order requires that the unified statement address 4 specific questions with binding yes or no answers. First, did Donald Trump declassify the documents at issue through any formal or informal process before leaving office? Second, if so, what was the specific mechanism and timing of that declassification? Third, does the defense claim executive privilege protects any of the documents? And if so, how can such privilege apply to declassified materials? Fourth, does the defense claim the Presidential Records Act grants Trump personal ownership or retention authority over the documents? And if so, how does that claim interact with classification status? Andrew Weissman, former general counsel of the FBI and a key member of Robert Mueller's special counsel team, told MSNBC that Judge Cannon's questions are brilliantly designed to force Trump into an impossible choice. He explained that any answer to question 1 determines the answers to questions 3 and 4, creating a logical chain that eliminates the ability to shift positions. If Trump claims declassification, he loses executive privilege and the Presidential Records Act becomes irrelevant because declassified materials are not presidential records subject to special protection. If he claims documents remained classified, the declassification defense disappears and he faces the full force of statutes prohibiting retention of classified materials. Here's the kicker. The order includes a section titled Consequences of Inconsistent Subsequent Filings that legal scholars say is virtually unprecedented in its directness. Page 47 states that if defense counsel files any motion, brief, declaration, or other court submission in any proceeding that contradicts the positions taken in the unified statement, the court will treat such filing as evidence of bad faith warranting sanctions, potential contempt proceedings, and referral to appropriate bar disciplinary authorities. This isn't a warning or a suggestion. It's a binding order that effectively ends Trump's ability to pursue contradictory strategies, depending on which court offers the most favorable forum. Don't go anywhere. The most explosive part is coming next, and here's what should terrify Trump's legal team. Once they file the unified statement committing to a single theory, every other pending and future proceeding becomes exponentially more difficult. If they claim declassification in the unified statement, prosecutors in the criminal case will immediately move to introduce evidence that no declassification process occurred. Witnesses from the National Archives, former White House counsel, and national security officials will testify that no standing declassification order existed. The defense will be unable to pivot to alternative theories when that evidence proves overwhelming. Alternatively, if they abandon the declassification theory and claim Presidential Records Act authority, they concede that classified materials were knowingly retained, eliminating any defense based on Trump's belief the documents were declassified. The Espionage Act charges require only knowing retention of national defense information, not specific intent to harm national security. Once the defense admits Trump knew materials were classified and retained them anyway, claiming legal authority under the Presidential Records Act, they have essentially admitted every element of multiple criminal counts. This puts Trump and his attorneys in an absolutely impossible situation. On one side, Trump has publicly insisted for over a year that he declassified everything telepathically, that documents were automatically declassified when he thought about it, and that he had absolute authority as president to declassify anything. His public statements on Truth Social, in interviews and at rallies, have created a record of adamant insistence on the declassification theory. His political base believes this narrative completely. Abandoning it now would require Trump to admit he lied publicly for 18 months. On the other side, his attorneys have reviewed the classified documents at issue and know that many contain intelligence so sensitive that claiming they were declassified is legally absurd and factually indefensible. Sources familiar with the defense team's internal discussions told The Atlantic that multiple attorneys have privately acknowledged the telepathic declassification theory is untenable at trial. They pursued it strategically to create delay and confusion, never intending to actually litigate it before a jury. Now, Judge Cannon's order forces them to commit to it or abandon it publicly and permanently. And here's the truly devastating aspect. There is no middle ground. Judge Cannon's 4 questions are structured to eliminate partial answers or qualified responses. The defense cannot claim some documents were declassified while others remained classified because the criminal charges involve specific enumerated materials and prosecutors will hold them to specific answers about specific documents. They cannot claim declassification occurred, but they lack evidence of the mechanism because the order requires identifying the specific process and timing. Every potential hedge or qualification is foreclosed. Legal and constitutional scholars are calling this order a masterclass in judicial management of litigation abuse. Quinta Jurecic, senior editor at Lawfare and a fellow at the Brookings Institution, wrote in a detailed analysis that Judge Cannon has essentially required Trump to do what every other criminal defendant must do: commit to a single coherent theory of defense and allow that theory to be tested at trial. She explained that the extraordinary aspect is not that a judge would require consistency, but that Trump's team successfully maintained contradictory positions for so long across so many proceedings before a court finally imposed order on the chaos. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even George Conway, a conservative attorney and frequent Trump critic who nonetheless has expertise in federal procedure, acknowledged that Judge Cannon's order is more restrained than it could have been. He noted that she could have sanctioned the attorneys immediately for the documented inconsistencies. Instead, she gave them 14 days to confer with their client and file a coherent position. That's an opportunity to avoid sanctions while still imposing accountability for the pattern of contradictory filings. So let's break down the impossible choice Trump now faces. First, if he commits to the declassification theory in the unified statement, he preserves his public political narrative and satisfies his base who believe he had absolute authority to declassify telepathically. But he guarantees conviction at trial when the government proves through witness testimony and documentary evidence that no declassification occurred. Former White House officials, national security advisors, and National Archives personnel will testify under oath that Trump never mentioned declassification, never initiated any declassification process, and showed no indication he believed materials were declassified when he resisted returning them. Second, If he abandons declassification and claims Presidential Records Act authority, he might create a slightly more defensible legal position on the narrow question of whether the PRA provides some retention authority. But he admits classified materials were knowingly retained, which satisfies the core elements of Espionage Act charges. He also destroys 18 months of public statements, admits he lied to his supporters, and faces potential additional charges for obstruction based on false statements in prior filings claiming declassification had occurred. Third, if he tries to file a unified statement that hedges, qualifies, or attempts to preserve flexibility through careful wording, Judge Cannon has made clear she will reject it as non-responsive and potentially sanction the attorneys for failing to comply with a direct court order. The 14-day deadline is firm. Extensions are unlikely given the order's explicit language about the need to resolve the inconsistency immediately to allow other proceedings to move forward. Finally, looking ahead to political implications, Trump faces enormous pressure from his campaign operation and political advisors who understand that abandoning the declassification narrative would be devastating to his claims of persecution and witch hunt. His entire political defense depends on arguing that his retention of documents was perfectly legal, authorized, and that prosecution is purely political. Admitting in a binding court filing that documents remained classified and were knowingly retained undermines that narrative completely and provides opponents with devastating campaign ammunition. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond Trump's immediate strategic nightmare, this ruling is really about a fundamental principle of judicial integrity. The court system cannot function if parties are permitted to maintain contradictory positions across different proceedings depending on which argument provides strategic advantage in a particular forum. When defendants exploit the fact that different judges typically don't coordinate or compare filings across cases, they weaponize judicial independence itself. Judge Cannon's order represents the judiciary protecting its own institutional integrity by requiring basic consistency and good faith from all parties. This scenario is creating absolute chaos within Trump's legal team and political operation. Sources familiar with internal discussions told Rolling Stone that the team held emergency meetings throughout the weekend of February 1st and 2nd to game out potential responses to Judge Cannon's order. The meetings reportedly devolved into shouting matches between attorneys who want to file a motion seeking reconsideration or emergency appeal versus political advisors who insist Trump cannot abandon the declassification narrative without destroying his entire political defense strategy. Some attorneys argued for immediately appealing Judge Cannon's order to the 11th Circuit, claiming it violates Trump's constitutional rights to present alternative defenses. Others pointed out that appealing a case management order is virtually impossible and would consume time Trump doesn't have given the 14-day deadline. The order would remain in effect during any appeal, meaning the unified statement deadline would pass while appellate courts decided whether to even hear the challenge. Meanwhile, Trump himself is reportedly furious at his attorneys for allowing the situation to develop where a judge could force him to choose between his public narrative and his legal defense. Sources close to Mar-a-Lago told The Guardian that Trump has been screaming at advisors that his lawyers should have prevented this, that Judge Cannon was supposed to be sympathetic to his position, and that the ruling represents a betrayal that proves even judges he considered allies cannot be trusted. The reaction has reportedly triggered discussions about replacing lead attorneys yet again, though finding new counsel willing to take over the case with a unified statement due in 14 days is virtually impossible. Things escalated further when Trump posted a series of messages on Truth Social on February 2nd attacking Judge Cannon personally, despite her prior rulings that had favored his positions. He called the unified statement requirement unconstitutional and corrupt, claimed it represented election interference designed to force him into false admissions, and suggested that Judge Cannon had been pressured or threatened by the Biden administration. Legal experts immediately noted the strategic disaster of attacking the one judge who had previously shown willingness to credit some defense arguments, particularly when Trump still has pending motions before her court. Stay with me. What comes next will completely change how you view the situation. Here's what makes Trump's response even more self-destructive. By attacking Judge Cannon and characterizing her order as corrupt and unconstitutional, He makes it virtually impossible for his attorneys to file the unified statement without Trump claiming they betrayed him or acted without authorization. If the legal team files a statement admitting documents remain classified, Trump can disavow it as the work of disloyal attorneys who caved to judicial pressure. But that would trigger immediate sanctions and potentially contempt proceedings against the attorneys for filing a statement their client repudiates. Alternatively, if the attorneys file a statement insisting on declassification to satisfy Trump's political needs, they commit to a theory every legal expert says is indefensible at trial and guarantee conviction. They also potentially expose themselves to sanctions when the theory collapses under the weight of evidence. The public attacks on Judge Cannon create a no-win situation where any filing will be characterized either as capitulation to a corrupt judge or as reckless advocacy of an untenable position. Legal experts reviewing Trump's social media attacks immediately recognize the deeper problem. Barbara McQuaid, former U.S. attorney and current University of Michigan law professor, noted in a CNN interview that Trump's attacks on the judge who issued the order suggest he fundamentally misunderstands his position. She explained that Judge Cannon gave Trump's team an opportunity to avoid immediate sanctions by allowing 14 days to reconcile their positions. Attacking her for providing that opportunity virtually guarantees she will be less flexible if the defense attempts to seek extensions or file something other than the direct answers her order demands. This goes far beyond Trump's legal jeopardy in the classified documents case specifically. It's about whether criminal defendants can indefinitely game the system by maintaining contradictory positions across multiple proceedings, preventing any court from issuing definitive rulings. If parties can argue declassification in criminal court, classification in civil court, and irrelevance of classification in appeals simultaneously, the entire concept of binding judicial determinations becomes meaningless. It's not just about Donald Trump's prosecution. It's about whether the federal court system has effective tools to require consistency and good faith from all litigants, regardless of their wealth, political power, or ability to fund parallel proceedings in multiple forums. If this blows your mind, hit that like button right now. Here's the situation. Judge Cannon has issued a 62-page order requiring Trump's legal team to file a unified statement of their position on classification status, ownership, and legal authority over the documents within 14 days. The statement will be binding across all proceedings. Any subsequent contradictory filing will be treated as bad faith, warranting sanctions and bar referrals. This eliminates Trump's 18-month strategy of maintaining contradictory positions depending on which court offered the most favorable forum. The defense must now choose between a declassification theory that satisfies Trump politically but guarantees conviction when tested against evidence, or abandoning that narrative and admitting classified materials were knowingly retained. When a federal judge forces a defendant to reconcile fundamentally incompatible legal positions that have been maintained simultaneously across different proceedings, we've entered territory that signals the end of strategic flexibility and the beginning of strategic catastrophe. The last time a judge imposed this kind of unified statement requirement on a high-profile defendant, Martin Shkreli was convicted within 4 months. The forced choice between untenable alternatives typically means the defendant has already lost but hasn't admitted it yet. If Trump's team complies by filing a unified statement committing to declassification, they guarantee conviction at trial when that theory collapses. If they abandon declassification and claim Presidential Records Act authority instead, they admit knowing retention of classified materials and eliminate core defenses while destroying Trump's political narrative. If they attempt to hedge or file something non-responsive, Judge Cannon has made clear she will sanction the attorneys and potentially hold them in contempt. There is no escape route that preserves both Trump's legal position and his political narrative. Keep a close eye on this story. The 14-day deadline for filing the unified statement is February 15th at 5 p.m. Eastern. Multiple sources indicate Trump's legal team is fracturing over what to file, with some attorneys reportedly threatening to withdraw rather than sign a statement they know will either destroy their credibility or expose them to sanctions. Judge Cannon has scheduled a hearing for February 16th to address any deficiencies in the statement and to consider sanctions if the filing is non-responsive to her order. Prosecutors are preparing to file supplemental briefs the moment the defense commits to a position. introducing evidence that contradicts whichever theory Trump chooses. And legal ethics experts are watching to see whether any defense attorneys request to withdraw from representation before the deadline, which would create a crisis over who represents Trump at this critical juncture.